Hi, good afternoon, everyone. Sorry, that was a very loud gavel in. I wanted to make sure everyone knew we were ready to start. Good afternoon, committee members. Welcome those listening in over the internet and on Zoom. Welcome to the Assembly Committee on Commerce and Labor. Madam Secretary, please call the roll.
Assemblywoman Carlton.
Here.
Assemblywoman Considine. Assemblywoman Dickman.
Here.
Assemblywoman Duran.
Here.
Assemblyman Flores. Assemblyman Frierson. Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Martinez.
Present.
Assemblywoman Marzola.
Here.
Assemblyman O'Neill. Assemblywoman Tolles. Chair Howdigi.
Present. Madam Secretary, please mark those members not present. Please mark them absent excused, and please mark them present when they arrive. Members, we have a short agenda today. We have 3 bills for hearing and 1 bill for work session. We're going to go ahead and move right into the bill hearing portion of our meeting today. And I see that we have our first presenter here. So I'm going to open the hearing on Senate Bill 260, which revises provisions relating to internet privacy. Majority Leader Canizaro, when you're ready, the floor is yours.
Thank you, Madam Chair and members of the Assembly Commerce and Labor Committee. My name is Nicole Canizaro. I currently serve as a senator from Senate District 6, which is located in the northwest portion of the Las Vegas Valley, and I'm pleased to be here today with you to introduce Senate Bill 260, which proposes to expand statutory prohibitions of the sale of certain personally identifiable information of a consumer. Along with me, Madam Chair, I do have joining us via Zoom Matt Robinson, who would like to give some comments on the background of the bill, and then the two of us would be able to answer any questions once we're done with the presentation. By way of background information, I think it is not uncommon for those of us who've spoken with our constituents to hear from them express frustration over the increased number of sales and robocalls offering services or products related to searches that had been conducted while on the internet. Likewise, just the mention of a product nearby your cell phone may result in a targeted ad on social media. These situations happen because a person's personal information that we think is protected was most likely sold to several different data brokers. And data brokers are companies that collect a person's personal information and resell it to other companies for marketing purposes. These data brokers do not have a direct relationship with the consumers whose data they have collected, so most people are not even aware of what is happening. Unfortunately, consumer data is also an extremely lucrative industry. According to TechCrunch, data brokering is a $200 billion industry. Over time, a single email address can be worth an average of $89, and this value can more than double if a person is a frequent traveler. Because it is such a lucrative business, there are over 4,000 data and information broker companies worldwide. Most well-known data brokers do offer an opt-out option for people to remove part or all of their data from being published, while others may try to hide it deep in their privacy policy or not post an option at all. Of course, the most effective way to avoid information leaks would be to simply go fully off the grid, get a burner phone, and only use a P.O. box and change your name to Jane Doe. But for most of us, that is just not a feasible answer. That is why it is so important to do everything within our power to limit the reach of those data broker websites where it is not wanted. During the 2019 legislative session, the legislature enacted Senate Bill 220 to prohibit an operator of a website or online service from selling certain personal identifiable information collected from a consumer. If a consumer submits a verified request to the operator directing the operator not to sell such information. I brought forth Senate Bill 220 after my constituents had expressed some of those same concerns about the privacy of their personal identifiable information. And now Senate Bill 260 takes the next step in protecting our constituents' personal information. It prohibits a data broker from selling that personal identifiable information if a consumer submits a verified request to the data broker directing them not to sell such information. I would like to walk the committee just briefly through the sections of the bill. Section 1.5 exempts fair credit reporting and fraud prevention organizations, publicly available information, and information and data processed pursuant to the Federal Driver's Privacy Prevention Act of 1994 from the provisions of this bill. And quite simply, the reason for those exclusions are that data is already covered under those particular provisions. Section 2 defines a data broker as a person primarily engaged in the business of purchasing covered information about consumers who reside in this state from operators or other data brokers and making sales of such covered information. Section 3 requires a data broker to establish a designated request address where a consumer may submit a verified request, which directs the data broker not to sell any covered information about the consumer that the data broker has purchased or will purchase. A data broker who receives such a request is prohibited from selling any covered information about that consumer that the data broker has purchased or will purchase. And furthermore, a data broker is required to respond to a verified request within 60 days of receipt. Section 3 allows a data broker to extend the period to respond to a consumer by 30 days if the broker determines that an extension is reasonably necessary, but the data broker is required to notify the consumer of the extension. Section 10 provides that if an operator of a website fails to make available to consumers a notice regarding collected covered information, they may remedy such a failure within 30 days after being informed, and only if it is their first time failing to comply with those requirements. Section 11 makes it an unlawful act if the operator of a website continues not to provide the notice regarding collected information within 30 days, and if they knowingly fail to comply with the requirement of such notice. Section 10 authorizes the Attorney General to seek an injunction or a civil penalty against a data broker who violates these provisions. If the Attorney General has reason to believe that that data broker has violated or is violating the provisions of Section 3, then they may institute an appropriate legal proceeding. Section 12 also provides that a district court that finds a data broker has violated Section 3 of this Act may issue a temporary or permanent injunction or impose a civil penalty. We also submitted to this committee 2 amendments that were worked out as of late yesterday. I think we're still making sure that the language accomplishes what we are trying to accomplish. With those 2 amendments, you will see one that I believe was submitted by Mr. Robinson, and then one that was submitted on behalf of myself. And these came from concerns after various stakeholder group meetings. And so the first amendment that you will see that has to deal with some of the telecom industries that we had been speaking to clarifies the definition of a data broker. The intent of this language is to help make it mesh with 2 other states that have implemented very similar laws so that those definitions match and we know exactly who we're talking about with respect to data brokers. There's an amendment to Section 4 that is a technical correction to avoid confusion between the data broker provisions of this bill and what currently exists for operators. And then the amendments to Sections 10, 11, and 12 further align the intent on clarifying the right to cure provisions. Those are provisions that will be enforced by the Attorney General. They extend the application of the cure provision to data brokers, and they basically make sure that we're providing that appropriate notice, and so the Attorney General can actually implement those. There's also an amendment that we have submitted for your consideration as well, that is friendly, that includes in the exemptions information that is otherwise covered by the Fair Credit Reporting Act and then also the Graham-Leach-Bliley Act. That also complies with how this law is structured for operators as a result of Senate Bill 220 from last session, because those types of data and information are already regulated under those provisions. Madam Chair, with your permission, I would like to turn it over to Mr. Robinson to add any additional comments, and then we'd be happy to take any questions.
Thank you, Majority Leader. Mr. Robinson, when you're ready. Mr. Robinson, I believe you're on mute. We can't hear you. No, we cannot hear you. Let's. Should I ask broadcasting to help them through? Should I ask Mr. Lewis? Do you want to try again, Mr. Robinson? Let's see if we can. Okay, let's see. It looks like we have IT working on it. 1 second. Okay, members stand at ease. Mr. Robinson, it looks like our BPS and IT are working on it, so hopefully we get you up and running.
Can you give it a...
Oh, there we go. Okay,
Here,
perfect.
This is Michael from Broadcast. Can you hear us?
Yes, we can hear you.
Perfect. Go ahead, Mr. Robinson.
Can you hear me?
Yes, we can hear you loud and clear now. Thank you, BPS.
Very good. Hey, Chair and members of the committee, thank you for taking the time to hear us out today. My name is Matt Robinson. I'm the Director of Public Affairs at Argentum Partners, and I'm here today on behalf of our client, Nevadans for Data Privacy. I'll be very brief. The Majority Leader did a great job of walking through the sections of the bill. Just a bit of background on this. The conversation and work on this started a couple of years ago in the 2019 session. Senator Canizaro alluded to with SB 220, and we looked at that as a great first step towards achieving security for Nevadans' data and their personal information. As with anything, over the course of a couple of years of being implemented, we went through and noticed some ways that we might be able to strengthen this and do it in a way that was good for everyone. And so that's what you see in front of you today in the form of SB 260. There are really three main goals here. The first one was to define data brokers and bring them into the fold and under the scope of this bill. Current statute only covers entities that collect your data or info through a website or a web page, and inadvertently omitted those that go out and purchase your data, often wholesale. They will then go sell it to other folks who may sell it to other people or use it to target you for specific products or services. So we thought it was important that everyone be treated the same under the eyes of the law in this. The second thing that we're trying to do here is we're expanding and clarifying the definition of sale. Again, in current statute, resale is the condition of qualification here. So that first initial sale of data or exchange of data is not currently covered. Your data is your data, and a sale or transmission of that is a sale or transmission of that. So we believe that, again, that first sale should be included in this provision as well. And lastly, there is a right to cure period in current statute, and it's 30 days. And we think that's a good thing. People make mistakes, companies make mistakes. It's the nature of business. Is what we heard from some of our stakeholders, specifically a group called the Electronic Frontier Foundation, is it appears that some entities and operators were perhaps taking advantage of this, and it wasn't having the desired effect as a deterrent, but possibly more of as a loophole to just continue operating however they have been and not rectifying that behavior. So as what we do in SB 260 is we go through and we clarify that you're afforded this right to cure period once. And moving forward, you will be expected to operate in compliance. And again, I'll be very brief, and I'll just kind of leave with some parting words. I think this is the second step now down a path that's probably going to be a fairly long conversation. This is a hot issue right now. Nationally, you have big tech companies coming before Congress to explain their actions and the way that they operate. You have high-profile breaches, as in the Equifax breach recently. You have the popularity of a movie on Netflix called The Social Dilemma. This is a conversation that the country is having. It's a conversation that our citizens are having in Nevada. And so we expect this to be, again, the second step in a long list of things that we can do in Nevada to help protect our consumers' digital info. And, you are your data, you are your info. And so this is important work. We appreciate the senator for going down this path with us. And we also appreciate that we had a great stakeholder group, and it really was a delight to work with everyone to bring forward a bill that we think is good for business and consumers alike in the state of Nevada. And with that, I'll stop and I'll hand it back to Senator Canizaro if she'd like to say anything else.
And Madam Chair, at this point in time, I think we would be ready to take any questions that the committee may have.
Thank you, Senator. Thank you, Mr. Robinson. Committee members, any questions for our presenters? Okay, we'll start with Assemblymember Considine.
Thank you so much for bringing this forward. I think everything that Mr. Robinson said concerning everybody paying attention to this and being interested in this is right on, so I appreciate it. I just had a couple of quick questions on Section 3. So each data broker shall establish a designated request address. How does somebody find that address?
Thank you for the question. Nicole Canizaro, Senate District 6, through you, Madam Chair, to the Assemblywoman. So this is a request address, and we went through this too with Senate Bill 220, where they are required to provide that on their website as a way for the consumer to actually contact them and say, hey, you know, I don't want my data to be sold. So it should be placed on the website in a readily available place where folks can find it.
Thank you very much. It's good to know. And then just my second question was same section, but in subsection 4. When they receive this letter and they have 60 days to respond, during that 60 days, can your data be sold, or does somebody expect it to not be sold the day that they receive it?
Thank you for the question, Assemblywoman Nicole Canizaro, Senate District 6.
You can go directly to the member.
Thank you, Madam Chair. Assemblywoman, that is a great question. It is not delineated in the language here. What we were trying to do was to make sure that they had enough time, if they receive, you know, a wide volume of these particular requests, that they would have the time to be able to go through them and then figure out where that data may exist and make sure that it was removed. But I don't think that that is specifically addressed by this language and is a good question. My anticipation would be that they likely would be proceeding as they ordinarily would, so somebody's data may be subject to that. Certainly wasn't the intent, but we wanted to be able from either the broker or the operator side, which is what is in current law, to allow them time to be able to actually find that data and then identify it as something that couldn't be sold. But that's a great question.
Thank you very much, Senator, and thank you, Chair, for the questions.
Okay, next we will go to Assemblymember Hardy.
Thank you, Chair, and good to see you again, Senator. So my questions are kind of along the same line as my colleague regarding the address. So that was my first question, was where they would find it. And so is that a physical address that they would be sending, not an email? And then next would be the verified request. Is that just a consumer just simply writes a letter saying, don't sell my information, or is it anything more formal than that?
Thank you for the question, Assemblywoman. Nicole Canizaro, Senate District 6. So in Section 7, it has the definition of a designated request address. And we worked on this last session as well, so that it was a number of different things, because smaller businesses may not have they may have a toll-free number that works better than a particular email address. And so in that definition, it includes an electronic mail address, the internet website, or a toll-free telephone number to submit that request. And we wanted to make sure that that was one of the concerns that we had heard last session with respect to where that information could be sent, and wanted to make sure that it would accommodate both smaller and larger folks. And so that definition now, as you can see in Section 7, is just including data brokers. So it'd be the same for them. They could do a toll-free telephone number, an electronic mail address, or an internet website for folks to be able to submit that. And then again, I believe we left some of the definitions of the verified request a little flexible as well. And you can see that in, let's see here, section 9. Yeah. So the verified request and what would have to be submitted is left pretty flexible with respect to that request, so that it's not overburdensome for the consumer to have to say, well, I have, you know, this information, this information, this information. It has to be something that the operator, the data broker, could verify, in that if you're sending it from an email address and you give them your name and they have your information, and that's why there's also that flexibility in the time, as I mentioned to one of the previous questions, for them to be able to respond. But we left that flexible because we didn't want to put in a bunch of parameters that either would make it complicated for the consumer to be able to submit when they're really just trying to remove their information. It could be as simple as, this is my name and here's the email address I've been using to interact with your particular website or your particular service. And we also wanted it to be something that, depending on that particular data broker or the operator as it exists under current law, would be able to, adopt practices to verify what that was. So it is intentionally left a little flexible for that reason.
Okay, thank you. And I appreciate that, because we wouldn't want, well, it has to be, this exact wording, this exact way, and the broker could say, oh, well, we don't have to do it because it wasn't this specific. So, thank you.
We will now go to Assemblymember Kasama.
Thank you, Chair, Assemblywoman Heidi Kasama, District 2. Thank you, Senator. This is really important. I know we're all concerned about our privacy. My question is just stepping back one step. So this is how we're going to send the information. How do we find all these data brokers? So maybe you could give an example of that. So if I'm a consumer and I want to submit this, where do I go? How do I find them? Because I'd like to do that now.
Nicole Canizaro, Senate District 6, and thank you, Assemblywoman. I think we all do, and that's sort of the reason for bringing the bill. And so, what we've put into the bill are obviously the parameters with respect to the verified request address, and for people to be able to submit that. I think it's a good question of how do you know who exactly is selling your data. Obviously, some of that is on the part of the consumer to when you're interacting with a website or with some place that you may be providing personal identifiable information, to be able to go ahead and opt out that way. I don't know if Mr. Robinson has any further highlights that he might be able to put on that particular question. Some of this is on part of the consumer to make sure they're protecting their information, just like you wouldn't leave your credit card sitting out on a table, or you wouldn't, you may protect your PIN when you enter it as you're buying gas, that kind of activity. Some of that is on the consumer to go ahead and find that verified address and submit the request. But what we did try to do was make sure that is something that is readily apparent, available, and is easy for the consumer to comply with. But I don't know if Mr. Robinson had anything else to add on to that.
Matt Robinson with our Argentum Partners, for the record. That's an interesting question, and it's part of the crux of this, right? It's such a pervasive issue, and people are so digitally active nowadays. It really is difficult to pinpoint, especially when you're talking about operators in general. Data brokers are a little bit different. They're lead generators, they're background check websites. They're kind of a different function than generally who people interact with on a daily basis. So the short answer is it's very difficult to find out if a data broker has your actual data. Other states, and as we said, this is a first or second step down a somewhat long path to address these issues. But some states have actually implemented data broker registries. I believe it's Vermont and California that have those. And so there is a website that consumers can go to and see if they've interacted with any of those companies, or they could go and theoretically just send blanket requests to all of them that says, hey, should you ever come across my data, please don't disclose it or sell it. So I think that's something that we're going to have to look at addressing down the road. I'm not sure this exact goal does that, but it definitely gets us further down towards that end goal of being able to identify these folks and then take your data out of their possession.
Thank you.
Members? Okay, next up we have Assemblymember O'Neill.
Thank you, Chair. Senator, I hope this is a simple question because I'm sort of building upon what my colleague to my left had to say, is how quickly can we enact this? But the other side of it is, have any of the data brokers, et cetera, had any pushback on enacting the protections for us? There is no date on the bill, enacting date, so it goes to the automatic date of October. I was just wondering, can we do it earlier? Is there some issue, some data, something or other bridging in there that we have to deal with first?
Nicole Canizaro, Senate District 6. That is a great question that I actually have not asked him. I'm sure that, I would venture to guess that one of the answers you may receive is that they would need and want the time to be able to set up the verified request address and to make sure they had processes in place to start processing any requests that did come through. But obviously, I think the sooner that we can do something here to protect data, the better. And so obviously would invite any answers to that question that may exist on part of some of these data brokers. That would be my guess as to what one of the answers may be.
The sooner the better, if I may say. Thank you. Thank you, Chair, for the time.
Okay, members, any other questions? Okay, seeing none, we will move into the support testimony portion of the bill hearing. Is there anyone in Carson City wishing to provide testimony in support? Welcome, Mr. Walker.
Good afternoon, Madam Chair and committee members. Matt Walker on behalf of AT&T. AT&T had, along with other wireless carriers, had some initial concerns with the consistency of the definition of data broker in this bill. After many, many hours of great conversation with Senator Canizaro and other stakeholders, we've reached a consensus amendment that you'll find on Nellis that creates much more consistency and hopefully will also offer some additional clarity to consumers as these bills are rolled out across the country. Thank you very much.
Thank you. Hi, good afternoon, Ms. Bells.
Good afternoon, Madam Chair, members of the committee. Jeanette Beltz, Jeanette, last name Beltz, Belz, here on behalf of the American Property Casualty Insurance Association. Really want to thank Mr. Robinson for working on the amendment that's in Nellis regarding the changes to organizations that are already regulated through the federal privacy laws, including Fair Credit Reporting Act and Gramm-Leach-Bliley. These help to protect those that are already regulated under the federal law, so it makes it all consistent. Thank you.
And thank you for your testimony. Is there anyone else in Carson City? Okay, broadcasting, is there anyone on Zoom wishing to provide testimony in support? Okay, broadcasting, can we please check the telephone line?
To testify in support on Senate Bill 260, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 742, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Chair Howdy and members of the committee. My name is Jimmy Lau, first name Jimmy, last name Lau, with Ferrari Public Affairs representing Verizon. We would like to echo the sentiments of our telecom colleagues and thank Majority Leader Canizaro for working with us on the proposed amendment on Nellis, especially regarding the definition of data broker. So thank you for your time and have a good weekend.
Thank you for your testimony, Mr. Lau. Broadcasting, next caller.
Chair, there are no more callers in support at this time.
Thank you. Can we please check the telephone line for those wishing to testify in opposition? Seeing no one here in Carson City and no one signed up on Zoom.
To testify in opposition on Senate Bill 260, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 070, please slowly state and spell your name for the record. You'll have 2 minutes and may begin. Caller with the last 3 digits of 070, please press star 6 to unmute.
Good afternoon, Chair and members. My name is Cameron Dimitri. Dimitri is spelled Demetre. I'm the Executive Director at TechNet, and TechNet's the national bipartisan network of tech CEOs and senior executives that promotes the growth of the innovation economy and represents over 85 companies and 3.5 million customers. I've heard, I haven't seen the latest of the amendments, but with that said, I'd like to review those before I make my comments as it relates to the data privacy broker component. But while we appreciate the recent inclusion of the Driver's Privacy Protection Act exemption, TechNet respectfully must continue to take an opposed unless amended position on SB 260. While we are still seeking additional federal exemptions included in other privacy laws, including the Fair Credit Reporting Act and the Graham-Leach-Bliley Act, from the previous stakeholder meetings, it was our understanding that data regulated by the FFCRA would be exempt from the measure. We believe this exemption is important as the federal law already provides robust protections for consumers while allowing responsible use of data for permissible purposes. Additionally, we also previously requested the bill recognize data regulated by the GLBA, which is important both for compliance with federal law and for operational consistency amongst states. Non-financial institutions have data that is subject to the requirements of GLBA and that they receive the data from a financial institution pursuant to certain delineated uses that they pass on for uses expressly authorized by the GLBA. And additionally, we're seeking additional clarity on the definition of data broker. It sounds like there's conversations already that have been productive in this rate, but TechNet advocates for a similar data broker definition to Vermont in order to avoid a patchwork of definitions what entities are considered a data broker in the eyes of state legislatures. And lastly, TechNet is seeking a right to cure process consistent with other states that provides for the ability to remain even in incidences where a previous violation has occurred. The right to cure benefits consumers by incentivizing companies to be forthright in identifying potential problems. For these reasons, we are opposed to this measure and consideration.
Thank you for your testimony, Mr. Dimitri. BPS, next caller, please.
Chair, there are no more callers in opposition at this time.
Okay, thank you. Seeing no one here in Carson City wishing to testify in neutral and no one signed up on Zoom, can we please check the telephone line for those wishing to testify in the neutral position?
To testify in neutral on Senate Bill 260, please press *9 now to take your place in the queue. Caller with the last three digits of 485, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Thank you. Good afternoon, Chair Hadigi and members. Mackenzie Warren with McDonald Carano on behalf of the Consumer Data Industry Association. We want to recognize the sponsor, Majority Leader Canizaro, for meeting with TDIA several times and just for the general direction of the amendments thus far. These amendments really help keep a clear line between what's federally regulated and what's highly regulated by that framework, and then what's regulated by the state. Just a quick nod again to the Senator and to Mr. Robinson with Argentum for being so responsive. We are working on some further refinements to address those activities regulated by federal law, and we look forward to having those worked out and hopefully supporting the bill by the work session. Thanks so much, Chair.
Thank you, Ms. Warren. BPS, next caller, please.
Caller with the last three digits of 081, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Chair and members of the committee. For the record, Dylan Keith, DYLAN-KEITH, Policy Analyst with the Vegas Chamber. I wanted to thank the Senate Majority Leader for meeting with stakeholders and the Chamber to discuss the intent of the bill and the policy issue at hand. Based on the feedback that we received from our members, the Vegas Chamber is neutral on the revised version of SB 260. We appreciate the efforts to narrow the definition of data broker and address the curing effect to be maintained at 30 days, which we support. Thank you, Chair and members of the committee, for your time.
Thank you for your testimony. BPS, next caller, please.
Chair, there are no more callers in neutral at this time.
Okay, thank you. Majority Leader Canizaro, would you like to give any closing remarks? Okay, with that, I will close the hearing on Senate Bill 260. Next on our agenda is Senate Bill 290. I will open the hearing on Senate Bill 290, which enacts provisions relating to prescription drugs for the treatment of cancer. Senator Lang, thank you for joining us. Welcome to the Commerce and Labor Committee. When you're ready, the floor is yours.
Thank you so much. Thank you, Madam Chair, Madam Vice Chair, members of the committee. For the record, I'm Roberta Lang, representing Senate District 7 in Clark County. I am pleased to present Senate Bill 290 in its second reprint, which seeks to allow diagnosed patients with stage 3 or 4 cancer to be granted an exception to the step therapy protocols. Cancer is the second leading cause of death in Nevada and in the United States. The incidence of cancer in Nevada is exacerbated by lifestyles of the state's population, according to the American Cancer Society. Approximately 16,970 new cancer cases will be diagnosed in Nevada this year alone. Approximately 5,410 cancer deaths will occur in this state in the year of 2021. And the average annual age-adjusted mortality rate for cancer deaths per 100,000 persons in Nevada is 157, compared to the national rate of 155.5. Individuals who have cancer face tremendous financial burdens to treat the disease. If they have health insurance, they may still find themselves owing thousands of dollars to healthcare practitioners and facilities. Individuals without health insurance face an additional burden of not being treated adequately for their disease because of their lack of insurance. In fact, the United Health Foundation reports 15% of our state's population avoid seeking care due to cost. Health insurers provide coverage for health-related services, including prescription drugs, but patients also must follow certain utilization management processes before coverage of service begins. These practices are currently known as step therapy or fail-first protocols. Generally, health insurers use step therapy to lower costs, while healthcare practitioners tend to prescribe the most effective treatment for their patients, but may not place a priority on prescribing low-cost treatments. However, a health insurer's step therapy policy may override the practitioner's recommendation for a certain treatment. Step therapy requires patients to try less expensive treatment options first and restricts coverage for certain prescriber types, such as treatments conducted by specialists. As a result, expensive treatments, which may be the most effective, can only be prescribed if a more inexpensive treatment first proves to be ineffective. At least 12 states have enacted legislation that addresses step therapy practices, often allowing patients to appeal process within a certain time frame. Exceptions to step therapy processes. During the interim, the Legislative Committee conducted an interim study concerning the cost of prescription drugs and received written testimony from various stakeholders demonstrating that step therapy causes barriers to patients, access to care, and advocated for changes to current practices. Too many of our state's residents will unfortunately face cancer diagnosis, and advocates requested that the legislature remove any unnecessary barriers to the cancer drugs that they need. Chair Howdigi, with your permission, I will do a brief bill summary. Senate Bill 290 requires certain health insurers to grant an exemption of its step therapy protocol upon a receipt of a complete application from an insured or intending practitioner of the insured who's been diagnosed with stage 3 or 4 cancer. That includes supporting clinical rationale and documentation if a treatment under the step therapy has not been effective at treating the cancer symptoms of the insured, or if the delay of treatment would have severe or irreversible consequences for the insured, and the treatment under the step therapy is not reasonably expected to be effective. Or a treatment under the step therapy is contradicted or based on peer-reviewed clinical evidence will likely cause an adverse reaction or other physical harm to the insured, or prevents the insured from performing his or her occupation or daily activities. Or the insured is stable under treatment of the prescription drug for which exemption is requested, and the insured has previously received approval for coverage of that drug. Or finally, any other condition for an exemption is met as prescribed in the regulations adopted by the insurance commissioner. Health insurance must respond to a step therapy exemption request within 72 hours of the request. A health insurer is required to respond as expeditiously as necessary if the attending practitioner determines that a step therapy process may seriously jeopardize the life or health of the insured. Health insurers may request as supporting documentation the insured's medical records demonstrating that the insured has tried other drugs, including in the step therapy protocol, without success, or demonstrates that the insured has taken the requested drug for a clinically appropriate amount of time to establish stability in the relationship with cancer. Health insurers are required to provide coverage for the requested prescription drug in accordance with the terms of the applicable health insurance policy. The insurer may limit the coverage to 1 week's supply, but must cover the drug for as long as necessary to treat the insurer if the attending practitioner determines after 1 week that that drug is effective. An insurer may conduct a review not more frequently than once a quarter in accordance with available medical evidence to determine whether the drug remains necessary to treat the insured for the cancer symptoms. Health insurers are also required to post an easily accessible location on their internet website maintained by the insurer a form requesting an exemption from a step therapy protocol. And finally, a health insurance policy issued or renewed on or after January 1 of 2022 must include the coverage required by this bill, and any provision of the policy that conflicts it is void. Madam Chair and committee members, thank you for the opportunity to be here. This is important legislation that has the support of the insurance companies, the prescription managers, and many medical professionals. I urge your support, and with that, I'm happy to take any questions. But before I do that, let me say I have 2 amendments that are going to be posted. The first one is to change the date that I mentioned. They put the default date in the bill when we had asked for January 1, 2022. So that has to be amended in the bill. And then also in section 1, number 5, you will see that on the review committee, it says that they have to provide the names and the occupation of the people on the review committee. In talking with many people in the medical field, putting someone's name on there can cause an adverse problem for doctors and people in the medical position if the person that put the application in is denied. And so we're going to remove the names part, just the names, and keep where they practice will still stay in the bill. Thank you.
Thank you. And Senator Lang, I'm sorry, could you give me the section for that second amendment?
Yes, Chair. It is section 1, number 5.
Section 1.
On page 3.
Okay, perfect. Okay, members, any questions for Senator Lang? I'm going to go first to Vice Chair Carlton.
And thank you very much, Madam Chair, and thank you, Senator, for walking through the bill so well for us. I do appreciate that. I'm looking at a second reprint, and unfortunately, I did not have the opportunity to look at the original and then the first reprint. So I'm just trying to, compare silos next to each other. So originally, this bill covered everyone, and then it was amended to take PEB out, but then it was amended again to put PEB back in. Was Medicaid ever included?
Thank you for the question, Roberta Lang, Senate District 7, for the record. Madam Vice Chair, yes, Medicaid was included in the beginning. The reason Medicaid was removed because our state currently is in a situation where that would have put a fiscal note on the bill that would have possibly caused the bill not to pass. And we felt it was more important that we get this bill passed out of committee or out of the legislature, get it into law. And in 2 years, when I believe the state will be in a better financial position, that will be my first priority.
And thank you, Senator, and I appreciate that. I've always been of the philosophy a cancer patient is a cancer patient. Whether they're poor or not, we should try to do everything we can to get there. And I'm not going to turn this into a Ways and Means meeting, but this does have a fiscal note with a second reprint. Apparently, the fiscal note was not there and then back because of the PEB change. So it currently does have a fiscal note of over $713,000 for PEB, which I'm not sure is entirely accurate because they asked their third-party manager to come up with a number. So I think we would need to investigate that a little bit deeper to make sure. But if it comes down to some of the cost of cancer treatments, $713 isn't a whole lot of money when you start comparing them to cancer drugs. But I think there might be someone from Medicaid available, Madam Chair. I would like to get a statement from them if it's possible. It seems to me as though with the way this bill is drafted, it looks to me as though it would be the cost of the review of the oncologist as this would move forward. And I don't think Medicaid uses step therapy. So I'd like to get that addressed if it's possible. Thank you, Madam Chair.
Sure, and Madam Vice Chair, we have removed the language about the oncologist because oncologists aren't always available to sit on these committees for review. So in section, it is a registered nurse or pharmacist, and that would be in section 6, the letter 1, C, or the number 1, and then C.
Okay, thank you. Section 6, 1C.
And Ms. Slemowitz, did you want to address Vice Chair's question?
Sure, I certainly can. Thank you, Madam Chair, and Beth Slamowitz, Senior Policy Advisor on Pharmacy for the Department of Health and Human Services, for the record. And thank you, Vice Chair Carlton, for the question. And so just for clarification purposes, step therapy is allowed in Medicaid, but currently fee-for-service Medicaid does not utilize step therapy at all. But I do believe that the managed care organizations do utilize step therapy as a utilization tool for their formularies and preferred drug lists. It's also referred to as a fail first type of policy or protocol. So I do think that that's probably where this would be impactful, would be to the managed care organizations if Medicaid was included. And I believe there's a section of the bill, reading it, I believe that the MCOs are exempt.
So would there be a way for us to estimate what the impacts would be if they looked at who they're currently treating moving forward? Is there a way to come up with hopefully a reasonable number so that we would understand the impact?
Yeah, I'm guessing that the managed care organizations, what they would need to do is look at the current medications, the oncology treatments that they have any kind of step therapy applied to, and what that looks like from a utilization standpoint, that if they then have to now not allow that step therapy to happen, or to allow a member to be able to request an exemption, how that would fiscally impact their plan, which then would, of course, trickle back to an expense to the state from the drug cost standpoint.
And then the match would be dependent upon the Medicaid recipient, whether it's the standard FMAP or the newly eligible, whichever category they would fall in. If they were the newly eligible, it's 90 cents on the dollar. So it's just going to cost the state 10 cents on the dollar. But on the other, it's about 68. So it would cost us maybe 30 some cents per dollar on those drugs. So if I could please request trying to get some information if we can, because I feel very strongly that a cancer patient is a cancer patient. And since we've already got one fiscal note on this thing, we might as well just, if you're going to put one foot in the water, you might as well just jump in and go from there. So thank you very much. If you could help us with that, we would appreciate it.
Of course.
Thank you, members. Any other questions? Oh, Mr. O'Neill?
Thank you, Chair. I think my question's a whole lot easier and less complicated, less expensive too. But it is a concern. At several places in the bill, it talks about the advocate for the insured. And I assume that's a family member or social worker, but nowhere does it define how you identify the advocate. And I'm trying to give you the position of two family members that maybe don't see it differently than the patient does. How do we identify who is the true representative or that advocate?
Thank you, Assemblyman, for the question. So the advocate for the insured could be a family member. It could be the physician who is helping filling out the paperwork that they're submitting to the insurance company. So it could be it could be anyone that that patient might choose.
If I may, Chair, just for clarification, so there is no formal declaration necessary?
No, sir.
Okay. Thank you. Thanks, Senator. Thank you, Chair, for the time.
Thank you, Assemblymember, for your question. Next, we have Assemblymember Hardy.
Thank you for the question. And I had the privilege of serving on that interim prescription drug committee. And this was one of the items we discussed that I thought was a really good idea, especially when you're dealing with illnesses such as cancer, that, you know, the more expensive medications could help someone. And to have to go through all the steps to get there when a delay in treatment can sometimes mean, you know, be the matter of someone surviving or not. So thank you for bringing this bill forward. I just had a question on page 6 where it talks about the insurer may initially limit the coverage to a 1-week supply of the drug, and then the practitioner would determine if it was effective. I was just wondering, 1 week seems short. Is that a long enough time to determine, well, it isn't working, so they can't continue it? Is that a fair amount of time?
Thank you, Assemblywoman Hardy. So this arose because many of you may remember Peggy Pierce, who was an elected official in the legislature. She had cancer, and she got medicine, and the medicine, you're right, is very expensive. And she took the medicine for less than a week and had a horrific reaction to it. And then the medicine is like $1,000 a pill, right? And so it's $30,000 a month. She had this horrific reaction, couldn't take the medicine, and now the insurance company had just covered that drug, and she can't take 27 pills, right? And so it was a huge amount. So in talking with the insurance companies, that they felt that if it was a week, and people, and there could be an appeal process, that there's always an appeal process in the insurance, in people's insurance, but if they did 1 week, that would be enough time to find out if they were going to have a reaction right away to it. And then if they did, there would be not the huge loss of the coverage of the medicine. And then after that first week, they could go and get their prescriptions regularly. So it's only for that first initial time that they're taking the medicine.
Thank you. That's interesting to know. So let's say in a situation like that, they did have a reaction. Could they then go maybe to another medication, or would they have to go through the whole process again?
Thank you for the question, Assemblywoman Roberta Lang, State Senate 7 for the record. Yes, they could work with the doctor and go to it, and the insurance company to go to a different medication, because they've already been approved through the exemption of the STEP therapy program.
Next, we will go to Assemblymember Dickman.
Thank you so much, Chair, and thank you, Senator Lang, for this bill. I think any of us, which is probably most of us who have had family members going through cancer treatments, will be very appreciative of this. I was just curious if you've had any pushback from the private insurers.
Thank you, Assemblywoman Dickman. The answer is no. In fact, I pulled everyone together early on, and we talked about everything, and initially everyone was against it. And as we talked and we were able to work it out, and I could tell them why this bill was so important, we found ways to work together to come up with this bill that works for everyone.
That's great news. Thank you so much. Thank you, Chair.
Thank you for the question. Assembly members, any other questions before we go to testimony? Okay, seeing none, I am going to move us into testimony in support. Is there anyone in Carson City wishing to testify in support? Okay. Seeing no one signed in on Zoom, BPS, could we please check the telephone line?
To testify in support on Senate Bill 290, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 131, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Chair Howdigy, members of the committee, my name is Connor Kane, CONNORCAIN, and I'm testifying in support of SB 290 on behalf of Comprehensive Cancer Centers of Nevada. We thank Senator Lang for her tireless work to craft legislation that will truly help patients. We have submitted a letter in support of SB 290 and would urge your support as well. Thank you.
Thank you, Mr. Kane. BPS, next caller, please.
Caller with the last 3 digits of 720, please slowly state and spell your name for the record. You will have 2 minutes and may begin.
Good afternoon. My name is Carrie Harrington. That is CARIHERINGTON. I'm the director with Nevada Cancer Coalition. We are in support of SB 290. This is the first step forward in addressing step therapy for our cancer patients. There's very rarely a one-size-fits-all in cancer treatment and care. And so we're really excited that this bill is a start in mitigating the potential negative impacts of step therapy for our oncology patients. Thank you so much.
Thank you for your testimony. BPS, next caller, please.
Chair, there are no more callers in support at this time.
Okay, thank you. Is there anyone here wishing to testify in opposition in Carson City? Okay, seeing none and no one signed in on Zoom, can we please check the telephone line?
To testify in opposition on Senate Bill 290, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Okay, thank you. Is there anyone in Carson City wishing to testify in neutral? Is there anyone on Zoom wishing to testify in neutral to Senate Bill 290? Okay, BPS, can we check the telephone line?
To testify in neutral on Senate Bill 290, please press star 9 now to take your place in the queue. Chair, there are no callers in neutral at this time.
Okay, thank you. Senator Lang, would you like to?
I apologize. Someone just raised their hand. Should I go ahead and move forward and take that caller, Chair?
Yes, BPS. And that was for testimony in neutral, correct?
Yes, correct. Caller with the last 3 digits of 139. If you could please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Chair Howdigy and members of the committee. My name is Laura Rich, Laurarich, Executive Officer of the Public Employees Benefits Program. PEB had previously placed a fiscal note of approximately $713,000 per fiscal year, but this fiscal note was later removed as a result of the original amendment, Amendment 409. Section 9 of the amendment provided an exemption to insurers who use a formulary. However, the latest amendment, Amendment 442, removes this language, and therefore PEB has submitted a new fiscal note to reflect this. In addition to the fiscal impact, PEB does have some concerns with the exception granting requirement. Currently, PEB relies on our pharmacy benefit manager to review these types of cases using the STEP therapy program. The PBM uses an independent team of physicians and pharmacists to make formulary decisions using FDA-approved guidelines and clinical justifications. And although PEB has chosen to implement STEP therapy, the goal of STEP therapy is not to stop the member from taking the right therapies, especially for cancer. Within the PBM STEP therapy processes, there's an exception process that members and their doctors are able to leverage today. The concern is that the bill appears to place the burden to grant this exception now onto PEB to make the final clinical decision, and PEB does not have the expertise on staff to be able to perform this function. Thank you for your time today.
Ms. Rich, I do believe we have questions for you from the committee, so if you would please stay on the line. Vice Chair Carlton?
And thank you. And Ms. Rich, thank you very much for calling in and walking us through this. So because there have been a number of changes, I just want to make sure that I understand it. So with the exception language, even with some of the changes that have been made, because the PBM actually manages this for you, I don't think I quite caught exactly what the issue is so that we know what we need to fix. If you could state it again, please.
So sure. Thank you for the question, Assemblywoman Carlton. Yes, the concern here is that, and Laura Rich for the record, the concern here is that the exemption process or the exception process, it looks like because the PBM does that for us today already through STEP therapy, it implements a separate process, and it appears from the way that our staff has interpreted the language that PEB would then make that final decision as to whether or not this is that exemption would be granted. And the problem from a PEB perspective is that we do not have the clinical expertise on staff to make that. So it would fall back onto the pharmacy benefit manager, which would already have done that through the STEP therapy process, if that makes any sense.
Thank you very much, Ms. Rich. That made it a little bit clearer for me. So basically you're saying that your contract with your PBM manages this function for you. PEB does not manage this function. So we would need to be explicit in the language that would say that if an insurance company had someone doing this for them, that it wouldn't have to be done twice, that you could use what was provided to you as dealing with the appeal process so that you wouldn't have to, in essence, redo what you're paying your contractor to do. So we would just need to clarify that that decision by your manager would be, in essence, be a decision by PEB.
Correct, yes.
Okay, I got it. Now, if Madam Chair, if you give me just a little bit of latitude. So, Ms. Rich, so actually the fiscal note was, as we said earlier, it was there, not there, there. Do you know where it actually is right now? Is the 713 still your mark in the sand, or is that changing?
Right. So Laura Rich, for the record, yes, it's we have just basically placed the original fiscal note on again because that First Amendment did away with the language that would require an insurer that uses a formulary such as PEB to to meet the requirements of the bill. And in this situation, that language in the latest amendment, that language was removed. And so the original fiscal note is, it was placed back onto the bill. I believe I had staff submit it last night. So it is an estimate because, again, we don't know specifically how many of our cancer patients are in stage 3 and 4. We don't get that kind of information. And so the PBM had to use an estimate of, what that would look like. So that's a best guess type, estimate that we provided based on the information we received from our pharmacy benefit manager.
And thank you very much, Madam Chair. And Ms. Rich, if you could get me a little more, our fiscal staff is going to be asking for this, a little more detail on the population you're looking at, the total population versus the percentage. That way we can extrapolate if we would need to for Medicaid or anything else. I think we need a little bit more information to dive in on this. So thank you very much. And if you could get that from your PBM, I would greatly appreciate it. Thank you, Madam Chair.
Thank you, Vice Chair, and thank you, Ms. Rich, for staying on the line to answer those questions. Okay, at this time, I will go to Senator Lang for any closing remarks.
Sure, thank you, Chair. So I'd like to first say, I'd just like to give you an example. So if I went to the doctor right now and I was diagnosed with stage 3 or 4 cancer, currently under insurance protocols, I would have to start with a step 1 medicine. And if that didn't work, I would go to a step 2 medicine. If that didn't work, then I could go to a step 3. But what this bill is trying to do is say if you go to the doctor and you're diagnosed with step 3 or step 4 cancer, your doctor can petition the insurance company to skip over the 1 and 2 and immediately get the step 3 medicines that will be most beneficial to you. And when we talk about patients in insurance companies that currently have cancer in stage 3 and 4, I'm not sure that gets you to the answer of who would need a stage 3 or 4 medicine, because if they're currently in stage 3 or 4, they would be getting stage 3 and 4 medicine. What we're looking for is the people that are going to the doctor and being diagnosed with stage 1 or 2 that need to jump to a 3 or 4 because that's what they have. So I think it's really important to keep that distinction there. It's kind of complex. We worked with the prescription benefit managers on this bill. They were part of the discussion. And so this is kind of the first time I've heard about this. But I would also say the federal government currently has a bill about step therapy and exceptions. It was in the last session and it was renewed in this session. And currently Senator Jackie Rosen has signed on in the Senate, and in the House, Congressman Mark Amodei has signed on. So and what their bill does, it treats every kind of disease. I chose to concentrate on the disease that affects Nevadans the most. And because it would be fair to say that insurance companies are skittish about how much this is going to cost. But what I can tell you is in my research, states like Washington and California have laws just like this that allow this, and their insurance costs are lower than Nevada's insurance costs. So everybody thought the insurance costs would go up. They actually went down. It didn't affect their insurance costs. And to be fair, they have a bigger pool which they can draw from, and that's important too. But I think we have to be really careful when we think about how much it's going to cost, because you have to do apples to apples and you can't do apples and oranges. And so I'd encourage you to look at this bill. And Vice Chair Carlton, I would be so thrilled if we could include Medicaid in this bill, because I really want to do that. I was thinking about where our state was and not knowing the cost. That's why I exempted it from the bill in this time. So thank you for your attention to this matter. I hope that we can vote it out and head to the floor or finance, wherever we might be going. But thank you so much.
Thank you, Senator. With that, I will close the hearing on Senate Bill 290. Our last bill for bill hearing on the agenda is Senate Bill 320. I see Senator Neal here, so at this time, I would like to open the hearing on Senate Bill 320, which enacts various provisions relating to food delivery service platforms. Welcome, Senator Neal.
Hey, good afternoon. I think whoever sat in this one was way smaller. Okay, I'm sorry, you guys. All right, so I am Senator Dina Neal, representing District 4, here to present SB 320. So we're going to quickly go through this bill. This bill has gone through a series of iterations. You guys should have received an email last night that had 5 changes to the bill, and then we have an additional change on Section 19. If anybody's ever ordered food from third-party food delivery services during this pandemic or before, you have realized either that it has come to be a little bit more expensive than it used to be, and that these companies are in a space where we all had to depend on them because we were unwilling to go outside because of the pandemic and because restaurants were at pretty much zero capacity. And so this bill is set out to at least try to engage in some of the practices that started to pop up and appear during the pandemic. So just to quickly go through the bill, so sections 3, 4, pretty much 3 through 10 are all definitions, including 11 and 11. And so those are just the general definitions to try to understand who's what and who's the user, who's the third-party delivery platform. The key provisions are really 12 through 19. And they're the ones that have we have gone through a series of changes and discussion on. I'm going to go through 12. Actually, I should back up. I need to go through Section 4 because we actually have an amendment on Section 4. So in Section 4, where the food service delivery platform, which gave you a definition, the amendment that you guys have on Nellis, we had to change this because as the bill sat out there for about a month, we got an email from TaskRabbit. If anybody knows what TaskRabbit is, you're nodding, but I don't even know what TaskRabbit is. But apparently, this definition captured TaskRabbit, and they were like, we don't want to be captured. And we agreed, and so so there was amendment to Section 4, which basically said we added additional definition of what does not constitute a third-party delivery company. We do not wish to capture TaskRabbit or this part of the market because they do not charge a restaurant commission fee and would conduct their business from the perspective of a customer versus a delivery company. So the amendment for Section 4, Sub 1 reads, food delivery service platform means an internet website, online service, or mobile application which allows users to purchase food from multiple food dispensing establishments and arrange for same-day delivery or same-day pickup of such food. Food delivery service platform does not include websites, mobile applications, or other electronic services that do not post food place menus, logos, or pricing information on their platform, and they do not assess any commission or other charge to a food place in connection with the delivery of its menu items. So I want to make sure I put that on the record because this session has been very special, and when people don't hear their amendment, they start panicking. Okay, so now I will go to Section 12. So Section 12, this was a provision in the bill that we were trying to get at individuals who might have been doing some menu stealing and putting information for a restaurant that they didn't have permission to actually have their information on their food platform. And so this provision basically says that unless a food delivery service platform has entered into a written agreement with the food dispensing establishment and that is expressly authorized, that they should not have a restaurant's menu on their website. Section 13 basically says that when they need to remove it. So this basically spells out that if they find out that the menu is on the website, They now have to remove it within, they said, it's a timely manner, but, and then it's within that 48 hours, because that was an agreement. And then also, there's in sub 3, a penalty. I pulled this penalty from Rhode Island. There are other states that are actually trying to deal with this issue, and so actually Rhode Island had a penalty of $1,000 per day of the violation, and I thought that was pretty steep. So I dropped it down to $500 for Nevada. That if a third party food delivery platform has a restaurant's menu on their website without permission, you need to remove it. If you're told to remove it and you don't, we start fining you. So Section 14 lays out the intellectual property. So it came up during this period of time that we've been out of session that food delivery service platforms were using the likeness, trademark, or intellectual property of a restaurant. This spells out that you need to have the written consent. Do not go around stealing images of a restaurant, putting it on the platform, and you know you don't have permission to use it. And so this then also adds a civil penalty if a company violates this provision, and it kicks in a $500 day violation for each day of the continuance of the violation, and it constitutes a separate and distinct. So this kicks in, we find out it's on there, you're told, take my KFC logo off of your website, or, you know, we could even do the Kevin Hart Christian chicken, but take it off the website, or it's going to be a $500 fine. I have to joke, it's been a rough day today. And then in Section 15, basically, this says we have the right to bring an action against the food service delivery platform in the sum of $5,000 or the amount of the actual damages sustained, whichever is greater. And then in Section 16, this is the disclosure provisions, which has an amendment to it. And these disclosure provisions caused Ms. Daslich gray hair, and then I was a secondary recipient of the gray hair. And then you guys probably were the third, because I'm sure that they were like, hey, SB 320 is coming your way. I hate it. Please, please, please change this bill. And so in Section 16, the amendment that we have for this part on the disclosure, Section 16 has been amended to take out the average percentage a restaurant can pay, and now only requires a third-party delivery provider to provide a statement that the restaurant is charged a commission that is separate from the delivery fee paid by the customer. This amendment takes out the proprietary information charged by third parties, as well as any information regarding what the restaurant pays. And Section 16 now reads that if a commission is disclosed pursuant to paragraph C, a statement that indicates that a commission is to be paid by the food dispensing establishment in connection with the online food order, including the highest commission, expressed as a percentage of the food purchase price charged by the food delivery service platform provider to any food dispensing establishment in Nevada. That was what our agreement is, and our amendment. And if you guys have questions on Section 16D, you will have to ask Ms. Dagelis, because she represents the Restaurant Association, or you can ask Assemblywoman Carlton. Because I don't have knowledge on how commissions work. So the next section is Section 17, which says that basically, if a food delivery service platform provider determines that it's not feasible to disclose the information required pursuant to Section 16, that they may submit a request to the Commissioner of Consumer Affairs about the alternate manner in which they would like to disclose this information. We have talked to Mr. Reynolds over at B&I, and basically what they're going to do is
do regs to try to take the fiscal note off the bill, since this will go to the Consumer Affairs and they will have a role in any kind of issues that pop up. And Section 18 also deems the acts in 16 and 17 as deceptive trade practice. Now for Section 19, I'm going to let Ms. Daslich explain that one, because that is the one that has gone through, I think, at least, how many reiterations? Like 6 or 7?
Yeah, I think 6. Good afternoon, committee chair. For the record, Alexandria Daslich with the Nevada Restaurant Association. So Section 19 has gone through numerous changes, including the percentage that a restaurant is, or I should say a third party is charging a restaurant. So that was pushed down from 20% to 15%. So we've lowered that temporary cap from 20 to 15%. That was done because credit card fees were excluded, and we've already passed a similar cap in Clark County that is still active, and we wanted to just mirror the jurisdiction, make it easy to implement. And the third party has agreed to that lowering of the cap temporarily. In addition, we've delegated that control to the county. We've changed that from the governor, and we've delegated it to the county for the purposes of that May 1st deadline. We hope that that was just something that could be determined by each different county. They can kind of see, because it's going to be based off of dine-in capacity restrictions. So it's going to be based off of capacity. So if they're at 100% capacity with no social distancing, it would no longer apply. But if a county is still, in fact, practicing social distancing and they're requiring a limited capacity, then that cap would be in effect in that particular county. So again, we're just trying to delegate that to local control. In addition, there is an exemption that we've added, and that particular exemption is for active caps that have already been instituted before April 30th. And the purpose of that is because of that Clark County cap that was passed last year. So that was the only exemption that is added.
And so with that, ladies and gentlemen, that is SB 320. So we are open for questions.
Thank you, and we do have some questions for you from the committee. I'm going to start by going to Assemblymember Flores.
Thank you, Madam Chair, and thank you, Senator, for that presentation. I wanted to go back to your conversation regarding the penalties for misutilizing someone else's menu or information on the website. I guess I want to understand what the issue is more. So first, if I'm a restaurant and there is a third party that is bringing business to me and picking up items, doing X, Y, and Z, and they have my menu, I'm trying to understand why what's the issue there. Number two, what if they just have links to your website? You come to the third party and there's just a bunch of links to the menus of other businesses. Is that an issue? If you could walk me through those two, and then I'll have a follow-up, Madam Chair, if I can.
Okay. So this is going to be a two-part, because I'm going to start, and then I'm going to let Ms. Daslich, and I don't know do you think Mr. Hashagogo could speak to that? But, so there was menu stealing going on, right? So this is not where we already have an existing relationship. This is you have used my information because you somehow want to either tie the restaurant into that platform, but you do not have permission to have that menu on there. You haven't had a conversation with the restaurant, but what you are doing is placing it on there, and then folks are putting in orders, but there is no actual contractual relationship between that restaurant and that third party delivery platform. And so that needed to be corrected because a couple reasons, and I'll let Ms. Daslich break that down. But the other part that you asked about the likeness and the intellectual property, once again, you could have the trademark or logo on there, and that you don't have it with permission, but you have it on there to try to, I guess, rope in the restaurant to start being a partner. So, because most people, you get on DoorDash or you get on Uber Eats, and you're like, hey, I really want something from #Go, but I don't see #Go. And so somehow it mystically shows up there, but #Go is saying, we don't have a relationship with DoorDash. So our stuff shouldn't be on there because we haven't entered into a contract. This tries to get at that bad behavior and stop that behavior. And so that's the provision, but more detail, I'll let Ms. Daslich, or we actually have, I believe he's the owner? Vice President of Hash a Go-Go on camera.
Do you want to go to Mr. Trent, Senator, or do you want to go to Ms. Dazzle?
I want to go to Ms. Daslich first, because I don't know if this has happened to him, but I'm sure he knows about it. I just know that that's why we have the provisions in the bill, because this was happening, and they felt like they had no rights. And there's no statutory construction that tells don't do this.
For the record, Alexander Daslich with the Nevada Restaurant Association. So the issue that we're having here is because when third parties take the menus, oftentimes they're outdated, or there requires further specification. There's also incorrect business hours that have been changed because of COVID. A lot of our menus have been pared down. So a lot of these types of issues are reflected on the restaurant. So when that customer puts in that order, and let's say it's for a Thai restaurant and it requires additional specification in terms of spiciness. If the third party just goes on behalf of the restaurant and it comes back not what the customer ordered and it's too spicy, then that customer can go back and create a bad review for that particular restaurant. So it oftentimes reflects badly on the restaurants. It's been something that's been an issue even before the pandemic, and it's been exacerbated since then.
Understood. Madam Chair, if I may, thank you. Understood. So, and that's what I was trying to get at, that it's not an issue of that the third party wasn't providing the item that you were purchasing. It was more a question of if you're getting exactly what you asked for, or little questions like that. But it's not that the third party was receiving an order, then they place it themselves, right? And there's a fee for that. And then at some point you're still getting your food and all that is happening. The question is just whether or not you have an accurate description of what the menu presently is or something like that. I guess I'm still not there on that, 'cause the restaurant's still making business and they're getting money. And if I want to tell somebody to go purchase food for me, if I want that, I'm just having a hard time understanding the penalties on that side. But I do understand taking somebody's intellectual property. I guess I could respect that. But I'm just having a hard time understanding the penalizing somebody when I'm entering to a third party said, go get this food for me. I mean, I guess I'm just having a hard time still getting there, but maybe you have some additional information. But it's not that they're not getting the food, and it's not that they're stealing, the third party is stealing money or anything like that. It's just a question of, are you getting the exact item that's available at the time? Or I'm assuming that's just what it boils down to.
Alexander Daslich with the Nevada Restaurant Association. Even if a restaurant does not have a relationship with the third party, there have been instances where they've showed up to the restaurant and pretended to have that relationship and then billed the restaurant at a later time. So there are instances where that has happened, and then they would be contractually obligated, according to the third party, to pay those fees. So there is more than just it being delivered cold or inaccurate or having bad reviews. So there are, and this has been a huge problem. In fact, third party has agreed to adopt these types of provisions, and I think I can say with full transparency that all three delivery providers are very open to this particular section. It's not contentious whatsoever.
Thank you.
If I could, because there was a second part to Assemblymember Flores' question that didn't get addressed about the links, and I just really want to hear the response to that too. Would it be a violation if they have links back to the menus of a restaurant?
I wouldn't say so, because so there's a link that drives you to the business of the individual, but I wouldn't go so far to say that it's the link. I would be reading the plain language of the section to say that if you have placed the order and you are somehow using their likeness, the trademark, or any other factor without permission, you need to remedy that. And there is a moment to remedy that, right? So there is a notice provision in there that if you find out that the link is on the website and you're saying, well, why are you advertising and I don't have a relationship with you, I think within that 48 hours, that needs to be corrected, right? And I mean, and I think you're worried about the fine, but there is also a window where you have time to fix it. if it's found out. So if it's something as menial as that, I honestly feel like if this is a business-to-business relationship, first of all, you shouldn't be using anything without anybody's permission. It's the same thing like with your law firm, right? You don't want anybody out there saying, oh, well, if they gave you a bad review, that falls on you. But if they're putting, like some other law firm is putting your website on their website saying, well, he doesn't really practice this version of law, and then you find out that your link is on some Canadian website, right? You're like, you have to deal with it. The question is, how would you like to deal with that? Especially if the link is giving a misrepresentation about your law firm. Does that make it better? I mean, because technically to me, if you have my information on your website and I didn't give you permission, whether it's the internet link or not, you are actually misrepresenting me if we don't have a written contract for you to do that. Because we don't have a business relationship. So why do you have my stuff? And that's how I view it.
Thank you, Madam Chair, for the indulgence. I guess we're just now starting to get into this weird, I mean, if a link is an issue, I'm just having a difficult time even starting to get there. Links are posted everywhere. We consistently do it all the time. There's third-party platforms, numerous third-party platforms where we put links on there. I'm just having we start getting into the world where you can't post a link, and that could be problematic. I just have a huge issue with that. I think this universe that we're getting into is so large, and we're casting such a wide net. But to say that a link could be problematic, I don't know that that's misrepresenting anything. You're just posting. And we can have this conversation offline. And I think I just need to kind of walk through it myself in my head. I get the taking in the intellectual property, but the posting of a link, if that would put somebody in violation and potentially would get a fine, I think I'm personally still not there. But I just need to dive further into it myself, and maybe we could have a conversation offline.
Yeah, so let's have a conversation about that, because in section 14, it's like if likeness is defined, it has a legal definition, and I think that, it falls into, I'm not sure it falls into a website link, but if you want the bill to say that it's not a website link that we're talking about, but simply when you get into the trademark, intellectual property, and the likeness, right? Like the actual likeness that I have a legal right to cannot be used without permission. And ultimately, that's my goal. But if you need it to be clear that it is not a website link, I don't have any problem putting that in there. If that is giving you heartburn to then charge somebody $500 fine for a website link. That's a non-issue. From all of the fire that we went through on this bill, that's a non-issue for me.
Thank you, Senator.
Next, we will go to Assemblymember Considine.
Thank you, Madam Chair, and thank you for bringing this bill. I'm going to go to section 16. But where I want to start is reading, when I read the Legislative Council's digest on section 16, where it says, bill requires a food delivery service platform provider to disclose certain information. What I sort of envisioned is that if I was ordering food, then on sort of the receipt when I paid, there'd be, here's the total cost of the food, here's the delivery fee, here's the credit card fees, here's any required tip, here's whatever else. So that's what I had in mind. So I'm kind of, and I think maybe a little lost about those changes to 16D. In the situation, if this bill were to pass, what would I see on that receipt now? Thank you.
Alexander Dazich with the Nevada Restaurant Association. I think also, I just want to clarify that when Senator Neal had mentioned Section 16 earlier, I think we included a section that was taken out later. It would just be a statement. So you would have the price of the food, any sales tax, the amount that the driver would be paid, and then at the very bottom, it would just be a commission statement. So just a statement that says that the restaurant is charged a commission fee in addition to the delivery fee that the customer pays. It's just a simple sentence. There's absolutely no percentages. There's no averaging. I just want to make that clear, that it's just, it started off as something that was supposed to disclose those types of rates and fees, but that since then has just become a sentence. So absolutely no proprietary or sensitive information that's contained in section 16 now.
Let me ask a follow-up? Yes. So then, if I have this right, so what you're saying is that commission that is charged to the restaurant would be in there somewhere, but it would not be delineated? Like I wouldn't be able to see it, it would be like in the food cost or something?
Correct. So it would say the food purchase price, the sales tax, any delivery fee or service fee charged, any gratuity, and then when I say a statement, I literally mean a sentence. So absolutely no numbers. It's just that restaurants are charged in addition to what customers pay.
Okay, so that would just notify, for a consumer transparency point of view,
Yes.
it would notify the consumer that there's additional money somewhere in there.
Correct.
And this is the statement as to why, but it doesn't tell you what or how much.
Exactly. And that's for the purpose of consumer education. I think a lot of people don't understand when they pay these fees, they think that they're covering the delivery fee, but the restaurant is charged up to 30% per order, which oftentimes absolutely takes out all the profit or any type of revenue that they would be able to make on these transactions. So again, it's to kind of educate the consumer side before and that's, I want to be clear, that's before that they place an order as well as on the receipt, if that's applicable, if there's a receipt provided.
Thank you very much. Thank you, Chair.
Thank you, and I'm going to jump in because I have a question on that section too, and I'm glad you touched on that, on why you guys want that disclaimer, because I didn't understand that portion of the bill. Like, what is the purpose of letting the consumer know that there is a commission, paid? Obviously, DoorDashers are they're getting paid for their work. You guys, like, a restaurant doesn't disclose that, they have to pay for the products that they buy to make the products that they're going to sell. Everyone knows, right, that there's a cost for doing business. And so, so what is the main purpose? What are you guys hoping to accomplish by letting the consumer know that there's a commission paid, or that, that the restaurant does help pay for the cost of delivery? I don't understand what the intent of giving that information to the consumer is.
Alexander Daslich with the Nevada Restaurant Association. The purpose of that is there's a total lack of transparency right now. I think when we're interacting with third-party delivery as well as just general tech companies, I think a lot of people have ideas of what they charge, or they're kind of ethereal ideas. And when we dealt with the Clark County Commission, it was really difficult to even pass that cap of 15%, because they said, well, there's all these different reasons why, and we have to take this into consideration and that into consideration. So we couldn't even get a basic breakdown of what they charge, why they charge it. And I know there's extenuating circumstances in which they take that into consideration. However, I think overall there's just been a lack of understanding, a lack of clarity, a lack of, transparency in general. So this is, supposed to kind of encourage the fact that, again, people understand that restaurants pay for every transaction, and potentially up to 30%, but of course we've taken out any type of number or any association to that, those particular types of relationships or proprietary information.
Okay, thank you for that. And I'm going to go to one of the members next, but I guess for me, with my understanding, like, I knew that there was as a consumer, when I would order from my local favorite restaurants, if they offered delivery service, I would always order directly from the restaurant, so as the restaurant could keep more of that money within them, right? And then obviously if the restaurant didn't offer delivery service, then I would order from a third-party app, right? But because I knew, and so I guess I'm under the assumption that everyone else knows as well, because but if the restaurant doesn't offer a delivery service, then there really is no other avenue for a consumer, right? Unless okay.
So
That was more of a, comment, but yes.
Chairwoman Hardy, I wonder if the Vice President of Go could illuminate a little bit more on that. So.
Thank you for the question. For the record, Jeff Trent, Hash House A Go-Go. the question comes up when people don't understand the magnitude of what the third parties charge, and they all charge differently. And they charge for marketing, and there is no one way that they do it. So it varies, and that's why we went to the Clark County to get the 15%, was to get some stabilization in the cost during this pandemic. But all these companies charge different fees, and they're not transparent about it to the guest because it doubles the cost. And that would slow their business, so they don't really show it too well. Thank you.
Okay, at this time, I'm going to go to Assemblymember Hardy.
Thank you, Chair. And I appreciate this bill because when we owned our sandwich shop through the pandemic, we had some of these same issues. We had never signed up for any of these delivery services because of the fact we didn't want to pay extra. My husband was like, I'm not going to pay this extra money, you know, I'll deliver it myself or whatever. So then when we, got into the situation of we couldn't have the store open for customers to sit in there, we had to rethink of what we were going to do. And ours is even a little bit different because as a franchise, some of the stores are corporate, some are franchise. So we had instances where a delivery person would come in to get an order, and we're like, this didn't come through our online service. Where did this come from? And then to your point, if the order, a customer was upset, we got a bad review, then we had to deal with our corporate office about, you got a bad review on Yelp and da-da-da-da-da. And it wasn't because of us, it was from a service. So, we went through and signed up with some of these, signed the contracts and things like that so that, we can increase our business. So I totally understand and grateful for this bill because I know it can cause a lot of issues for the business owner and for the consumers who don't understand. Why are you charging me so much? Or why is this, what are all these fees on here? So my question would be, I just want to make sure that since in section 19 talks about when there's a declaration of emergency, this bill is not just while we're in an emergency, this is like going forward from here on.
So I'll speak to this a little bit. So the conversations around Section 19 that have been ongoing pretty much for 2 months have been that it's going to be variable. So what we worked out and the amendment that we worked out was that if the county is still at a limitation, or if, let's say, because we go to 100%, but not everybody's vaccinated, and we find ourselves back in a flare-up, that this then becomes a variable that will come back in operation. If there is no actual pandemic or something that's being like the social distancing that's in play, it's not in play. The argument that was made to us was that it's a free market, you can't limit a free market, so we're not willing to agree to allow this to go in perpetuity, right? Ideally, yes, that would make sense to the universe, right? To allow for some kind of regulation over these entities. But they have persuaded enough people that Section 19, without the amendment that we currently have, which I believe is even changed even more so since last night's conversation, is the only way that we will be able to successfully get a vote on this bill, because they have actively lobbied to make sure that we couldn't have any regulation post-pandemic unless there was an actual flare-up or social distancing was still in play and the restaurants are not fully open. That's the only way that that provision will operate.
Alexander Daslich with the Nevada Restaurant Association. And the thought behind tying that to restaurant-specific restrictions is if we're not operating at 100%, then we're not really operating in a free market. So if they don't have that opportunity to completely have dine-in or offer that, then that's something that we feel should be curtailed temporarily. And of course, that's a temporary cap. And again, it's something that's been passed across the nation. I think 8 other states have already passed it, including Oregon, Washington. I think Texas is considering it, and I have a whole other list of states. But this is something, again, that is not new. It's something that is, temporary. So please keep that in mind.
Okay, thank you. I appreciate that. I completely understand. Thanks.
Okay, we're going to go to Assemblymember O'Neill next.
Thank you, Chair, for the time. Senator Neal, Ms. Drakulich, I want to thank you so very, very much. I was probably the cause of some of your gray hair and acid pills over the last few days, really going to Section 19. And I've got to say that I was opposed to the bill initially because of that in the free market, and you worked diligently. You were just tremendous in working this. I can't thank you enough for it. But I have another suggestion. It's the enacting date. Since we are starting to come out of the pandemic and we're going to local jurisdictions, I was reminded by some just how strongly the restaurants have been impaired by this, and was reminded by my dearest wife when we went out several weeks ago, and I witnessed an argument between I guess you would say the cashier and one of the food delivery places that had just done that. They had their own website, had pirated the connection into the local restaurant, and the restaurant had people calling them up just complaining to no end about what they were paying for and how dare they raise prices. It was price gouging, etc. So that's what really got me to understand this situation better, and I want to thank you. But as I said, you may want to look at the enacting date, because as we come out, waiting several months to put this in action may be too late for some of those restaurants. So that's my question as a suggestion, and I thank you for your work, and I thank you for the time, Chair, my very long statement.
So, thank you, Assemblyman O'Neill. We would be willing to make those changes. But if you get any additional phone calls telling you, I hate that, we're going to put that all on you, okay?
Okay, members, any other questions for our presenters? Okay, at this time, we'll move into testimony in support of Senate Bill 320. I don't see anyone in Carson City. Is there anyone on Zoom who wishes to provide testimony in support?
Jeff Trentwood.
Okay, thank you, Mr. Trent. When you're ready, you may begin.
Good afternoon. My name is Jeff Trent. I'm the Vice President of Operations of Hash House A Go-Go. Most of what we've covered this afternoon is relevant to our industry. But Assembly Flores and Assembly Hardy brought up a question about menu stealing, and I wanted to add a couple sentences to that. Without any written agreement, if what happened to Ms. Hardy happens and that third party goes away and leaves the food in the car, and there's a food illness created because of that, that third party is not liable. They have no insurance protection that covers the restaurant or themselves in that case. And so the insurance people come to the restaurant or because they're insured, they're going to try to tag us with that penalty. It doesn't meet what you insure with a written agreement that third parties are going to abide by the health department regulations. And then the trademark, we pay a lot of money to have our trademark secure and protected. And when third parties circumvent the by using it illegally, they circumvent the trademark law and diminish the brand possibly. And it is a big thing with a company when someone puts on a improper representation and has no right to do it. Regulating third-party delivery companies may seem like uncharted territory, but we have to put common sense laws in place to protect especially small restaurants. And I urge you to support this bill. Thank you for your time.
Thank you so much for your testimony, Mr. Trent. Broadcasting, can we please go to the telephone line?
To testify in support on Senate Bill 320, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 081, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Chair and members of the committee. For the record, this is Dylan Keith, DYLANKEITH, policy analyst with the Vegas Chamber. I would like to start by thanking the bill's sponsor for bringing this bill forward. The Chamber supports SB 320 because it brings transparency and parity between the interested parties, which at the end of the day benefits Nevada's consumers. As you have heard, our restaurants, which include small and family-owned operations, have been hit significantly hard during the pandemic. We believe this bill will help those small restaurants as they attempt to recover and rebuild. Thank you, Chair and members of the committee, for your time. We urge your support on SB 320.
Thank you for your testimony. Broadcasting, next caller, please.
Caller with the last 3 digits of 407, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Thank you, broadcast. For the record, this is Randy Thompson, RANDITHOMPSON, Nevada State Director for the National Federation of Independent Business. I first want to thank Senator Neal for bringing this bill. It's a very important bill, although complicated. And thank you, Chair Howdicke, for hearing the bill. NFIB has dozens of restaurant members, and I've heard from several of them, and these are the smaller restaurants, but I've heard from several of them about the lack of transparency with some of the food service delivery services. Yet these food delivery services have been the lifeblood for many restaurants this past year, so we appreciate that they are around. But we do support this bill as we think it will add transparency to these transactions, as Mr. Trent testified. Thank you, Madam Chair.
Thank you so much for your testimony. Broadcasting, next caller, please.
Chair, there are no more callers in support at this time.
Okay, perfect. If we could go to the telephone line, seeing no one here in Carson City and no one signed in on Zoom to testify in opposition, if we could check the telephone line.
To testify in opposition on Senate Bill 320, please press star 9 now to take your place in the queue. Chair, there are no callers in opposition at this time.
Thank you. Can we please check the telephone line for those wishing to testify in neutral?
To testify in neutral on Senate Bill 320, please press star 9 now to take your place in the queue. Caller with the last 3 digits of 490, please slowly state and spell your name for the record. You'll have 2 minutes and then begin.
Hello, everybody. My name is Cyrus Hojati, Cyrus, Hojjaty. I think it's very important to bring a lot of transparency to these delivery services and apps. I hear that many restaurants have been overcharged. They've been hit very hard. Many restaurants actually require the driver or the user, the delivery person, to use a card to order the food because they don't want to get the tablet devices and pay all the fees. So then the driver would have to spend a long time waiting for the food, and it's just very inconvenient. So these are one of the unintended consequences as a result of the current system. My concern is if this law gets passed, will this reduce demand for these programs And will this mean fewer work for these delivery drivers? Because a lot of these people depend on these jobs to make a living, and I want to make sure that they make ends meet. And thank you guys so much for bringing this bill. It's very important to talk about it. And if you'll excuse me, I've been hearing a lot of outside noise, I'm sorry to say. Thank you.
Thank you for your testimony. Broadcasting, is there anyone else in neutral?
Caller with the last 3 digits of 101, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Thank you. This is Terry Reynolds, Director for the Department of Business and Industry, TERRYREYNOLDS. Thank you for letting me address this in a neutral position. We, with our Consumer Affairs Unit, we see complaints in regard to this issue often, and we had in 2020, we actually had quite a bit more complaints over charges of products and food items. So I would suggest that you would request that the Department of Business and Industry, through their Consumer Affairs Division, develop regulations for disclosure of the statutory items under Section 16, as well as the items under Section 17, which require or where a provider may request the Commissioner of Consumer Affairs disclose the information on an alternative manner. We're happy to do that. We would work with the Consumer Affairs Division within the Attorney General's office and make sure that we cover the statutory requirements, assuming that this piece of legislation moves forward. Thank you.
Thank you, Director Reynolds. Broadcasting, is there anyone else on the telephone line wishing to provide testimony in the neutral position?
Yes, Chair. Caller with the last 3 digits of 903, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Jennifer Lazovich, L-A-Z-O, V as in Victor, I-C-H, on behalf of DoorDash. Although DoorDash does not support commission caps, we are testifying in neutral today. We want to thank Senator Neal and Alexandria Doslich for working with us on language in Section 19 that would make it clear that the temporary cap is in place for as long as there are occupancy and social distancing limitations on restaurants. If there are no occupancy or social distancing limitations on restaurants, the temporary cap would not apply. We came to an agreement with Senator Neal and Alexandria on the language late last night. The language that was posted on Nellis with the amendment isn't quite what we agreed to, but Alexandria did refer to it in the portions that we talked about in her testimony. So to the extent that further tweaks are necessary, we would just ask that we be allowed to continue working with the parties on language that clarifies when the temporary cap is in effect.
Ms. Lasovich, I believe we have a question for you from Vice Chair Carlton.
And thank you very much, Madam Chair.
Okay.
So since we have a representative of a company that actually does this, I think one of my questions is one of the things we just heard about is some concerns. So as the company operates, and I believe are your employees independent contractors? So if there was a problem with something that happened with the employee, would DoorDash be the responsible party, or would the driver be the responsible party? Let's say a sandwich was left in a hot car, 120 degrees. They're doing 2 hours worth of deliveries. That last sandwich ends up causing a problem. Is that on DoorDash's dime or is that on the driver? How do you see that?
Jennifer Lazovich, for the record, I do not have the answer to that question right now, but I would be happy to get it and follow up with you.
And thank you. I think that's one of the concerns that we have is we want to, at least I have, and being in the food industry for years, I understand what can happen. And I think you guys need to mark it down that the Restaurant Association and I are on the same page. One day out of 24 years, so I think that I need a gold star for that one. But I just want to make sure that if there is a problem, the consumer knows what's going to happen. And we heard from the gentleman from Hash House A Go-Go, and I have seen, I do not use these because of my perspective on food, but I have noticed folks telling me that they're having problems getting the quality of food that they know probably came out of the restaurant, but it wasn't the same quality by the time it got to their door. So if you could address that and send the answer to the chair and staff so we can share it with the committee, I believe that would be very helpful in our deliberations.
Understood. Thank you.
Thank you, Vice Chair. Broadcasting, are there any other callers in queue?
Caller with the last 3 digits of 069, please slowly state and spell your name for the record. You'll have 2 minutes and may begin.
Good afternoon, Madam Chair, members of the committee. My name is Rose McKinney James, McKinney-James. I'm the managing principal of McKinney James and Associates, and here today representing Grubhub. I appreciate the opportunity to offer some brief comments in neutral. We started this process in opposition, and I guess we can say we've evolved that position based on the amendments that have been discussed and approved by the Senate, and we appreciate the willingness of the sponsor and the Nevada Restaurant Association and the other delivery platforms to work toward addressing some of the key issues that you've discussed today in this bill. I think it's important to note that we appear to be turning a corner on the challenges created by COVID that resulted in these temporary restrictions. That said, I think we can acknowledge and expect that there will be some amount of transition to get back to prior levels of operations. We're pleased to have the opportunity to participate in the language that will ensure clarity around the menus, that they're being properly posted and based on a written agreement. I need to say that Grubhub remains fundamentally opposed to fee caps as a general principle, but we acknowledge the need for some balancing during the extraordinary circumstances of a pandemic. We're currently reviewing the new language that's now being discussed in Section 19. We look forward to working with the sponsor and the other parties to address this newly proposed language. We're hopeful that the parties can continue to refine and clarify the issues related to the expiration and understand jurisdictional considerations, and we remain hopeful that we can arrive at a mutually agreeable resolution. So I thank you for the opportunity to appear via phone today, and thank you very much.
Ms. McKinney James, we do have a question for you from Vice Chair Carlton.
Yes.
Hello, Ms. McKinney James. Nice to hear your voice. We do miss you in the building, I will say. So same question that I had asked Ms. Lazovich earlier. How does Grubhub look at their employees? Are they independent contractors? If there was an issue with food, who would bear the liability with that? I'm not asking you to give us the answer right now, but if you could provide us that information as we move forward, I believe it would be very helpful. Thank you very much.
Thank you so much, Rose McKinney James. For the record, I would be happy also to seek that information from the client, and I will get back to you.
Thank you, Ms. McKinney James. Broadcasting, if we could go to the next caller, please.
Chair, there are no more callers in neutral at this time.
Okay, thank you. Senator Neal, would you like to give any closing remarks?
Yeah, thank you, Madam Chair. I'd like to thank the Assembly Commerce and Labor for hearing this bill, tolerating my jokes, and we will continue to work on Section 19 and also with Assemblyman Flores on his changes and Assemblyman O'Neill.
Thank you, Senator, and I think your jokes were very appreciated from the committee. Yeah, thank you. Okay. Okay, committee members, we are going to move on to the next item on our agenda. We do have a work session today on Senate Bill 35. You should have your work session documents with you. I know they were emailed to you yesterday evening. With that, I will hand it over to Ms. Paslow-Thomas to present Senate Bill 35 for work session.
Thank you, Madam Chair. Senate Bill 35 revises provisions relating to the Private Investigators Licensing Board. It was sponsored on behalf of the Attorney General and heard in committee on April 21st, and there are no proposed amendments.
Thank you, Ms. Paslow-Thomas. Any discussion on the bill? Okay, at this time, I will entertain a motion to do pass Senate Bill 35.
So moved, Madam Chair.
I have a first by Vice Chair Carlton. Do I have a second? I'll second. I have a second by Assemblymember Marzola. Any discussion on the motion? Okay, seeing none, all those in favor, please signify by saying aye. Aye. Opposed? Motion carries. I will assign that floor statement to Assemblymember Marzola. Okay, that brings us to our last item on the agenda, which is public comment. Seeing that there is a delay from the feed for those listening and watching listening online and watching online, I will go through our public comment housekeeping while we give them time to call in. I would like to remind those listening that the period for public comment is an opportunity to discuss general matters that fall within the purview of this committee. If you direct your remarks to issues over which this committee has no oversight, I will ask you to redirect your remarks or terminate them. The public has already been given time to support or oppose specific legislation. We open and close hearings on bills so that we establish a record of the public testimony on the bill. Therefore, public comment is not intended to be a continuation of a bill hearing. I would like to remind everyone that we take 30 minutes of public comment and limit public comment to 2 minutes. Be respectful of committee members and other witnesses. Do not comment on testimony provided by other speakers and do not make personal attacks. You may always submit written remarks for inclusion in the meeting record. With that broadcasting, is there anyone on the telephone line wishing to give public comment?
Chair, the public line is open and working, but there are no callers at this time.
Okay, thank you so much. Okay, committee members, at this time, is there any comments from anyone on the committee? Okay, seeing none, then you should have all already received your agenda for Monday. Please note the start time. We will be meeting at 1 p.m. on Monday. Thank you and have a nice weekend, everyone. We are adjourned.